Thank you all for being here. So today's topic is about truth much stranger than fiction. I should introduce myself. I'm Brandon Garrett. I started teaching here this fall, but in my prior life, I worked as a civil rights lawyer for Peter Neufeld, our guest tonight. Our guest tonight, Peter Neufeld, also has a separate life as a filmmaker and film critic, and that maybe helps him relate to cases like the Earl Washington case, where the story is just so unbelievable and disturbing. It's not the kind of thing anyone could make up, and I think you'll be troubled by it, and I think you'll be interested to hear what has come out of it. As many of you may know, Peter Neufeld, along with Barry Scheck, co-founded the Innocence Project. And these are heady times. You know, last week there were 3 DNA exonerations just in 1 week. There are now upwards of 175 people living amongst us who have been exonerated by DNA evidence of their innocence. And you're going to hear today about one of those cases that's sending shockwaves throughout the Virginia criminal justice system. And this talk is one of the first criminal law colloquium you may have seen on the signs. There's going to be a series of these criminal law focused talks on different issues in criminal law. I want to thank, before our speaker talks to you, some of the people that helped put this together. The Dean's Office and the Law School have provided funding for this series of talks, of which this is the inaugural event. The Student Law Forum did a tremendous amount of work helping to organize this event. And the Virginia Innocence Project student group is also a sponsor of this event. And the talk will very much relate to the work that students are doing here at the University of Virginia Law School on innocence cases and on innocence issues. So everyone, you give a big hand for our first speaker here in the criminal law series, Peter Neufeld, from the Innocence Project at Cardozo in New York City.
I was just commenting to Brandon that it's great that no one sits in the first row if you're a law student. But what's so amazing is once you get admitted to practice, if you ever go into a court, they expect the lawyers to sit in the first row. And I wonder if this is something that happens just like that when you get your degree, and what will happen to all of you. Hopefully you'll have an opportunity to take lots of courses with Brandon Garrett. He was an extraordinary person. We started this Civil Rights Fellowship, and he was the first Civil Rights Fellow we had. And what made Brandon so unusual, particularly as a law student, is he had this attitude, which is, well, I'll get involved in some issue. I'll be working someplace and in litigating some novel theory, and there'll be an open-ended question. And so so he would leave the office, go back to the law school, write and publish a law review article on that issue, then bring it back to the law office, and because litigation takes so long, by the time the other side moves for summary judgment, the judge can cite to his article as to why the case has to go forward. And when you have someone who can do that again and again and again, you're in great shape. So if any of you decide to do that as well, we'd love to have you as Civil Rights Fellows in our office. June 4th, 1982, 23 years ago, in a town called Culpeper, which is not too far from Charlottesville. Even if you're not from Virginia, you pass it on Route 29 if you're heading north. One of those kinds of crimes happened that we like to call heater cases because they're so high profile. A young white housewife named Rebecca Williams was coming home from the 7-Eleven with her 3 small children. She got into her garden apartment. It was in a complex of 50 or 60 garden apartments. And shortly after she entered the apartment, a stranger came in through the front door, which had not been locked. And that stranger attacked her with a knife, repeatedly stabbed her, threw her onto the bed, raped her, stabbed her some more, and then fled the premises. Rebecca Williams staggered to the front door. She got outside. Some police came, some neighbors came. Before she fell into a coma and died, her last words were that a lone black stranger with a beard came in and raped me and stabbed me. And then she died. Well, needless to say, in a small town like Culpeper, this case was a heater. The press picked up on it immediately. Demands went out for the police, in this case the Culpeper Police Department and the Virginia State Police, to solve this terrible crime. No one felt safe in that community. The investigation basically stumbled along for a number of months. There were some leads, but nothing very useful. And nothing happened for about 11 and a half months. But then, on May 21st, 1983, 11 months later, about 75 miles away in Fauquier County, a young black man who was mildly retarded, named Earl Washington, Jr., was home with his family. He had had too much to drink. He got into a terrible fight with his brother over a woman that they were both interested in. And after his brother hit him, he left the family home, and he remembered that a woman who lived down the road, Mrs. Weeks, kept a gun on top of the icebox or refrigerator. And so he went in through her screen door, and he took that gun off the refrigerator, and Mrs. Weeks tried to stop him. And so he hit Mrs. Weeks with a chair, threw her to the ground, and then ran out of the house with that gun, went back into his own house, and shot his brother in the foot. He dropped the gun. He then ran out into the woods, and he sat there crying for the next couple of hours until the police came to arrest him for the assault on Mrs. Weeks and for shooting his brother in the foot. When the police of Fauquier County started questioning him about these crimes, he readily admitted his culpability. Initially, the police thought because the assault on Mrs. Weeks involved a woman that perhaps there was a sexual component to it. And these police officers recalled that there were 2 or 3 other rapes and attempted rapes in Fauquier County that had gone unsolved. And so they continued to interrogate Mr. Washington, and in short order, he confessed to all 3 of those other crimes. And then these 2 officers in Fauquier County remembered reading stories about a year earlier about that young white woman, Rebecca Williams, who had been raped and stabbed in her house in Culpeper. And so even though they didn't know many facts, they asked Earl Washington, "Did you kill that young white girl in Culpeper?" And eventually Earl Washington lowered his head to the table and said, yes, he did. And so the Fauquier police called the Culpeper police. And they were very excited that someone had now admitted doing it. And so both the Culpeper police officer and a state trooper from the Virginia State Police went to Fauquier County to interrogate this prisoner about the murder. They started the questioning. They didn't take any notes. They didn't record it in any way at all. And during that first hour, they claimed that Earl Washington not only again confessed to the murder, but in response to a series of open-ended questions, he offered extraordinary details about the commission of the crime that had never been disclosed publicly. And that is a technique that we've all seen on television, the notion that detectives like to hold back certain details, hoping that when they interrogate that suspect, he'll reveal them on his own, and that'll give them corroboration as to the reliability of the confession. It's a good technique. And so Earl Washington, they said, did exactly that. Some of the things he was asked was, for instance, "Earl, did you leave anything behind at the scene of the crime?" And he said, "Yes, I left my shirt." And his shirt had been recovered. And he said, "Well, where did you leave your shirt?" He said, "I left it in the top dresser drawer in the rear bedroom where the assault occurred." And sure enough, that's exactly where the shirt had been recovered by the police. And they said, "Why did you leave the shirt behind?" And Earl, according to the confession, said, "Because I bled on it and I didn't want to go out with the blood on it." And sure enough, bloodstains were found on that shirt. Well, this is very compelling corroborative evidence of that confession's reliability and hence of his guilt. And so Earl gets charged with the murder of Rebecca Williams. Now, the other 3 rape cases all eventually get dismissed because, in truth, there really was no evidence to convict Earl Washington of those other crimes. He had made false confessions. The problem with the Rebecca Williams case is that there was no victim to assess whether it was a truthful confession or a false confession. Rebecca Williams was dead. And so we went to trial. He was assigned counsel. He was indigent. The lawyer who was assigned to Earl had no experience in capital cases, in fact, had very little experience with any kind of serious felony. And he was given another attorney to help that man, but that man had even less criminal experience. So I'm going to move this away. There's people getting some, like, there's something. I don't think I need it. Can you hear me in the back? Okay. You can turn that off. And so those are his lawyers. Indigent, can't afford to retain private counsel, gets these lawyers. Under the laws in Virginia at that time, one of the first things that these lawyers wanted to do, because he seemed real slow, and they talked to his teachers in school, and they told him that he had tested in the mental retardation level when he was in elementary school and again in high school. And some of the lay people who knew him said that they thought he was mentally retarded. So they wanted him examined by a psychiatrist. But under Virginia's law at that time, he was not entitled to retain his own psychiatrist. He had to use the same state hospital doctor who had already been utilized by the prosecution to declare that Earl Washington was competent to stand trial. There was no money for certain investigators. There was no money for certain experts. And there was expert evidence in this case, because there was Earl's confession. There was the confession corroborated by the presence of the shirt tied to him. And there was semen stains that had been recovered on a blanket where the stabbing occurred, and semen that had been recovered from the victim's vagina during a post-mortem autopsy of her by the Virginia medical examiner. And the defense never reached out to an expert. And when they got the police report from the medical examiner's office and the testing that was done, remember this is long before DNA. All they could do was ABO testing, blood group testing. I don't know if you folks know anything about blood groups, but when I grew up I had to know my ABO type, my mom said, because on the way to school if I got hit by a truck and they had to do a transfusion, I'd have to be able to tell the doctor that I was A positive. I don't think people do that anymore. But in those days all they did was ABO testing. And so they had done the testing, and the ABO type on these stains found on the blanket were inconsistent with Earl Washington, and were inconsistent with the victim. But none of that was brought out by the defense at trial, and they never had an expert to help them. And so Earl Washington's defense at trial was that I didn't really confess. I just wanted to say things to get along, to make them like me. I was compliant, okay? Well, the jury didn't believe that. The jury believed instead a written Q&A that had been filled out by the detectives during the second hour of questioning, which Earl, although he couldn't read it himself, had initialed, okay, as being his statement after the police officers purportedly read it to him. And so with that confession evidence and the evidence from the detective saying that I asked him these open-ended questions, and without any prompting at all, he volunteered these details that only the perpetrator would know, his fate was closed in that day or two. I think it was a 3-day trial, right? And most of the trial, 3 days, was taken up with jury selection. The penalty phase was much quicker, I think about a half hour. The defense put on no mitigation evidence at all, and so he was sentenced to death. And Earl went to the death house in Virginia. He did his direct appeal. And then, of course, after his direct appeal, what he wanted to do was to take advantage of a state post-conviction remedy, to file a state habeas corpus petition. In those days in Virginia, you were not entitled to have a lawyer assigned to represent you if you were indigent in a post-conviction mode. You would on direct appeal, but not post-conviction. And so another inmate named Joe Giantano filed a class action lawsuit on behalf of the prisoners on death row, claiming that they should be entitled to have a lawyer assigned to represent them if they couldn't afford one, and to not do so was unconstitutional. While the class action was pending, a group of lawyers from Paul Weiss came down to work on that class action. And they were sitting there talking to Joe Giantano, and he said, listen, by the way, there's a guy, 3 doors down on the row here who's actually innocent. His name is Earl Washington, needs a lawyer. And so these Wall Street lawyers who love class actions but don't want to represent an individual say, I'm sorry, we can't help him. We're only here to do your class action. And they said, well, this guy is retarded and can't possibly represent himself in a post-conviction situation. They said, well, fine, we'll make him part of the class. And they said, no, no, that won't do any good because he's scheduled to be executed in about 2 weeks. And so these lawyers who had never represented a client before, who knew almost nothing about criminal law, rolled up their sleeves and spent the next several days in the cell because Joe Giordano said, I will no longer cooperate with you on this class action unless you walk down the hallway and help this man. And so they did, and they filed a petition to try and stay his execution. They succeeded. As a side note, you should know that the actual class action lawsuit went all the way up and was defeated. The courts found no constitutional right to have counsel assigned to you in a post-conviction context. One of the reforms that have occurred since that time, however, is that the Commonwealth of Virginia now does appoint counsel for the indigent in a post-conviction situation, but it's never been determined to be constitutionally mandated. Meanwhile, Washington now has a stay. It's 1984, and the main claim he wants to raise in the 80s is that he had ineffective assistance of counsel because the lawyers failed to utilize the serological evidence. And eventually he goes up to the Fourth Circuit. It's denied all the way up the courts in Virginia. He goes into federal court with that same claim. And in federal court, claiming ineffective assistance, for those of you who have taken criminal procedure, they applied the Strickland v. Washington standard. And they found, or at least two of the judges found on the Fourth Circuit, that yes, he had ineffective assistance of counsel. The lawyers did not provide reasonable assistance. However, there's a second problem to Strickland, which is, nevertheless, there's no error because there was overwhelming evidence of his guilt, to wit, the confession that contained all these details that without any prompting, he disclosed and that only the true perpetrator would know. And so Earl Washington is back on death row. In about that same time, 1993, DNA testing was just starting to take off as a phenomenon in this country. And the lawyers who've been working on Earl Washington's case contacted us at the Innocence Project, which at that time had been in existence for about 2 years, and we offered to help. And through a series of negotiations, the state of Virginia agreed on their own, right? The governor agreed to do DNA testing. Now remember, at that point in time, there was no statute enabling someone to get post-conviction DNA testing. Virginia had something called the 21-day rule, which said that 21 days after a conviction is final, you can no longer go back into court with, newly discovered evidence of innocence. So under the 21-day rule, which was the most draconian in the country, if I was accused and convicted of killing Brendan Garrett and they never recovered the body, and then 30 days after my conviction, Brandon walks into town and he's seen at the local bar, I could not go into a court to vacate that conviction, even with that kind of evidence. I could only go to the governor and ask for mercy, ask for a pardon. And so at that point, the governor volunteered to do DNA testing. That governor was Governor Wilder. And the DNA testing in 1993 and the early part of 1994, just 2 weeks before Governor Wilder left office, indicated compelling but not dispositive evidence, they said, that Earl Washington was innocent. However, the governor reasoned that because of this confession, which contained all these exquisite details that only the perpetrator would know, he was not prepared to pardon Mr. Washington, but he would commute his sentence to life without parole if the lawyers agreed to go away and not raise any more applications in the courts. So, as any lawyer would in that situation, if you can save the client's life, you discuss it with the client, and then you take the deal, and which is what the lawyers did for Earl Washington at that point. And so Earl was then moved from the death house to general population to begin serving his life sentence. Well, DNA continued to progress and get better and better between 1993 and 1999. And so we went back and we asked the governor at that time if he would agree to more definitive DNA testing, which we believe could resolve any ambiguity at all. And at that point, again, because of the 21-day rule, we couldn't go into court. But this time, Governor Gilmore said nothing doing. He had his DNA testing. Governor Wilder gave him relief back in '94. I'm not doing anything. And so when a lawyer can't win in court, and when a lawyer can't go to the executive branch, and when the legislature is not giving you any break at all, the only thing left you can do, which is what we did, is we went to the press. And we recruited, at that point, Ted Koppel, who had a show called Nightline, And he was completely blown away by this story about Earl Washington, and particularly when he looked at the early DNA evidence and asked some experts on his own about how compelling it was. And he came down here with a team of reporters to Richmond, and he literally camped out on the governor's doorstep and continued to send stories to New York, to ABC News, until the governor finally relented and said, okay, we'll do the new DNA testing. And so the new DNA testing was done, and this time, the DNA testing revealed dispositively that the semen recovered from the victim's vagina could not under any circumstances have come from Earl Washington or the husband of the victim. Moreover, it found that the semen stains on the blanket matched a convicted serial rapist who was a black man who had a beard, who fit the description given by the victim, who was serving life in Virginia prisons, a guy named Tinsley. And so under those circumstances, Governor Gilmer said, I have no choice, but I have to pardon this man. I'm not going to pardon him on the grounds of actual innocence. I'm going to pardon him on the grounds that no reasonable juror could convict him, could not have a reasonable doubt about this case. And so he gets pardoned at that point. But we were still unsatisfied because other people were getting pardoned on the grounds of actual innocence. And Earl Washington's case was a very important case because he became the first man, the only man actually, to be exonerated off of Virginia's death row in the modern era, since they brought back the death penalty in the 1970s. So it became a very important case because people had to realize for the first time that the system was somewhat vulnerable. And so we then filed a civil rights lawsuit. And the civil rights lawsuit allowed us to do additional discovery and additional DNA testing. And in 2004, we learned that, in fact, the semen recovered from the vagina also matched Mr. Tinsley, the serial rapist. And so we knew then to a moral certainty that Earl Washington was innocent. And as a result of our finding that, it triggered an audit that Governor Warner ordered about the original forensic testing that was done by the Virginia Crime Lab, an audit that revealed that there were serious problems, both systemic and individual to this case, in the way that laboratory functioned, and reforms had to be implemented. Governor Warner, as a result of the first audit, then ordered a broader audit because of other irregularities that were occurring in that crime laboratory of 31 other cases. And you may have read a month or so ago, toward the end of his term, that as a result of that 31 case audit, 2 more people were exonerated. And as a result of those exonerations, one of his last acts as governor was to now be the first governor of the United States to require that there be a DNA testing done on over 300 old cases where people had never even come to the Innocence Project suggesting they were innocent, but nevertheless we needed to test the reliability of those convictions to get to the truth. And so Earl Washington became one of the 175 people that Brandon was talking about who've been exonerated through post-conviction DNA testing. And our Innocence Project at Cardozo Law School is responsible for more than half of those cases. In fact, we think that the number of wrongful convictions is certainly much higher than 175. In the first instance, more than 70% of our cases get closed out, even though our clients meet our criteria, because in the intervening years, the key biological evidence has either been lost or destroyed. Secondly, we're getting numbers from the FBI which indicate that the problem is much more serious. Since the FBI Crime Laboratory began doing DNA testing for law enforcement agencies all over the United States, they've been evaluating in what percentage of the cases when people are arrested based on eyewitness testimony, based on circumstantial evidence, based on confessions, and then the prosecutor wants to corroborate that evidence with a DNA match. Well, when they do the DNA testing, in 25% of the cases, the FBI excludes the suspect who's been arrested. So it doesn't take a rocket scientist to extrapolate from that, not that 25% of the people in prison are innocent, but certainly a lot of people who had been tried before the advent of DNA testing were convicted based on eyewitness testimony, were convicted based on confessions, were convicted based on jailhouse informants. And so if we could go back and look at those cases, we have a chance to exonerate some of those people. Now, not only did we realize that the number was much greater, but we also thought that this whole new DNA revolution could have an impact on the debate on capital punishment in this country. Because for years that debate had been mired in a political exchange, in a morality exchange, in a philosophical debate, and you're not going to get much movement either way from people when those are the issues. But what we were talking about for the first time was not morality or philosophy or religion or politics, but merely science. Namely, is the system sufficiently reliable, as revealed through these DNA exonerations, to permit an irreversible sentence, that is, execution, when it is so often the case that we can now reveal many, many years later, despite overwhelming, the person turned out to be actually innocent. And so many people of all political persuasions who had previously been in favor of capital punishment were modifying their position. The next thing we wanted to do with the Innocence Project, because we realized that it's not enough to simply exonerate people, because there's only a certain window of opportunity to do that, was to see what lessons we could learn from these exonerations. In other words, why are these people getting convicted in the first place if they're innocent? And if we could figure out and identify what those causes are, maybe we could come up with consensus remedies, reforms, ways of changing the criminal justice system that would reduce the danger of innocent people being convicted. And the reason we thought we could have traction on that issue in a way that all other criminal justice reform was unable to do in the last 50 years is with the realization to everybody that every time you convict an innocent person, not only does that innocent person suffer, but it means that the real perpetrator was not apprehended and is still out there committing very serious violent crime. So our concerns were not just a matter of human rights and due process, they also touched very significantly on public safety. And so we've been thinking about those causes, and we've been thinking about those remedies. Some of them are completely obvious to all of you. Eyewitness identification. 80% of these cases involve misidentifications by people. And we've implemented reforms to try and deal with that. Right here, as part of our agenda in Virginia, the Crime Commission has recommended, because they don't want to create a statute yet, they're hoping by powers of persuasion they will get law enforcement agencies to change the way they conduct eyewitness identifications. And it's a very simple kind of thing that we've learned from social science research, to wit that if the real perpetrator is in that six-pack like you see on TV or in the movies, there's no problem. You know, the victim or witness can pick that person. But if the real perpetrator is not in that group of six, okay, when the eyewitness looks at the six, what he or she is really doing is not making an absolute judgment, but is looking at the six and thinking to herself, who among these six people looks most like the guy I saw? And that's not a good thing if you want to make sure you get the real bad guy. And so instead of looking at six at one time, do it sequentially. Show them one at a time and take them back. So the witness is not comparing ears and noses and things like that. Is looking at the person head on and saying, is this the guy or isn't this the guy? Simple reform. Second reform. Don't have the police officer who's running the investigation conduct the ID. Because even if he or she means well, in the best of circumstances, you can't help but to say, you know, Mr. Garrett, I see you looking at number 3. What is it about number 3 that attracts you? Or, you don't have to look at number 5, why don't you move on? Those things happen even unwittingly. But if the person who runs the ID is simply an experienced officer who doesn't know who the suspect is and who the fillers are, you're more likely to get a reliable result. Next reform, false confessions. Earl Washington's case is a false confession. The beauty of Earl Washington's case is, once you prove to a scientific certainty that Earl Washington didn't commit the crime, because the victim said it's a lone black man with a beard who did this to me, okay? And then you identify through DNA testing a serial rapist who had committed the same kind of crime before using the same MO, right? And always worked alone, never knew Earl Washington. In fact, when he was interviewed by the police, he said that I'd never met Rebecca Williams, I'd never even been to Culpeper in my life. And when asked, well, how did your semen get inside her? He said the police must have planted it there. Now, if you're a prosecutor, you just love a false exculpatory statement like that, because it's so patently ridiculous you can use it to convict somebody. So we know that Earl Washington is completely innocent. Well, if he's completely innocent, then where did he get those spectacular, intimate details that only the perpetrator would know if they were non-public? Obviously, they were fed to him during the interrogation. It's the only place he could have gotten them, because the police swear they were non-public details. Well, how did that happen? Okay? We don't know how it happened, and the reason we don't know how it happened is because the interrogation was never recorded. So the simple reform for preventing these false confessions is tape record the entire interrogation. Not just the confession part like they do sometimes here in Virginia, not just that climax, that denouement, but actually the entire interrogation, the time the person sets foot in that room, turn that tape recorder on. And it's amazing how once police officers accept this as a reform, they love it. In Minnesota, for instance, when we first tried to utilize this reform, all the cops were resistant to it. Didn't want to do it. Didn't want to be that dog learning a new trick. But once it went on board, the cops now swear to it. Because they had all these cases where there was an unrecorded confession, and they said, the defendant admitted it was his gun. He said, nonsense, I never said that. Now all the officer has to do is press the play button. Okay? So false claims of brutality, false denials, all gone, as long as you have this reliable, neutral, objective record of what transpired. And you know what? The judges love it. Because the judges now, when someone challenges a confession, don't have to get into a he said, she said swearing match and listen to 2 days of testimony. They retire to the roving room with a videotape, press the play button, and then they render a decision. Much, much better situation. Bad forensic science. Part of the Earl Washington case was what happened in the crime lab, and they had made some mistakes in the original testing. The reform that we're talking about for bad forensic science is let's start treating forensic science the same way we do clinical science in America. There's an elaborate regulatory scheme that allows all of us who are consumers to have some confidence in the integrity of a clinical test that's done on you at a hospital or at a medical laboratory. None of those controls have ever existed the same way for crime labs. A lot of the forensic disciplines have never been properly validated, like medicines are. There is nothing equivalent to the FDA or the National Institutes of Health. There's none of that kind of verification, reliability, validation, those kind of studies, peer-reviewed publications. It doesn't exist for forensic science. Let's make it accountable. Let's also make them have audits when things go wrong, something else they never had to do. So we're doing those kinds of reforms. Bad lawyering. Here the lawyers obviously were in way over their heads. And the biggest problem in America in these cases is that the indigent don't get sufficiently competent counsel who have the resources to hire investigators and experts and do what's required in this case to make sure that the individual gets a truly meaningful defense. In Virginia, they're beginning to learn from that. Virginia, as you may know or wish to ignore, is 50th in this country. 50th, we were talking last night about 50th behind Mississippi, okay, in what they pay indigent lawyers who represent folks on serious felonies in the state. And it wasn't until Covington and Burling came forward and announced that they were about to file a major class action lawsuit to challenge the Virginia approach that all of a sudden the legislature announced here this week that they're going to seriously consider for the first time reforming that and taking the caps off of what lawyers for the indigent receive in these felony cases. And I can't overemphasize how important it is to get better lawyers. Because if you have better lawyers, they're more likely to investigate the eyewitness identification. If you have better lawyers, they're more likely to question the bona fides of the confession and do all those kinds of things. And so that's what needs to be done. What you need to know, and then I want to open it up to discussion. About 5 more minutes? Okay. Is two things. What's happening with these Innocence Projects, we're the first and we're the largest, but we now have about 30 of these Innocence Projects around the country. And it's really become a kind of burgeoning civil rights movement, where law students, journalism students, and the teachers are really concerned with the notion that we have this unprecedented opportunity to make criminal justice more scientific, more reliable. We're trying to use the DNA model as a lesson, if you will, on what good evidence should be, okay? What good fact-finding should be about. And let's see if we can reform all aspects of the system to give it the kind of scientific rigor that we do understand DNA possesses. And as we make the system more scientific, as we make it more reliable, ultimately we make it more just. So in that regard, one of the other things that's coming out of this whole innocence movement is an understanding of the need for all this new academic scholarship and new research and investigation into what had always been sort of the sacred cows of criminal procedure law. I mentioned misidentifications. Well, the problem is that the doctrine that's utilized nationwide, if you've taken criminal procedure, is the Manson versus Brathwaite standard, the Neal v. Bigger standard, where a court, even if there's an unduly suggestive out-of-court identification, looks at 5 different factors to assess the reliability of the identification. The problem is, and the social science research has shown, that at least 3 of those factors are self-reporting certainty by the victim and don't really have any kind of scientific rigor behind them. What's also interesting is, even though people might not necessarily agree with that, they can't ignore our data set. Because our data set is that in the 80% of the cases where there were mis-IDs, lawyers filed motions to suppress those identifications. And in almost every single case, the courts ruled, hey, guess what? It's a reliable ID. Okay, we found it to be reliable and therefore admissible. Well, the courts and appellate courts and habeas courts and Supreme Courts are finding reliable IDs, which ultimately, because of the serendipitous intervention of DNA testing, we now know to a certainty was unreliable because it was the wrong guy. So there's something wrong with the doctrine, because if it's getting this many mistakes in the way the analysis runs down. False confessions. Back in the 1980s, the Supreme Court stopped looking at reliability of confessions. All they cared about was coercion, voluntariness, okay? And ultimately now is, did you get your Miranda warnings? If so, boom, end of inquiry, everything else goes to wait. But what we see in the Earl Washington case, for instance, very clearly, is that here's a case where you can't prove coercion, okay? You tried to argue coercion in the state courts, it was rejected. We tried to argue coercion in the civil rights suit, rejected. But nevertheless, we now know through the eye of the DNA gold standard here that it was in fact a false confession. And the reason we know it's a false confession is because of the DNA. But we don't know otherwise how to prove that. If courts had a reliability hearing, and if the interrogations were tape recorded, then a judge would be in a position where he could determine, well, did in fact the defendant volunteer, as was reported in this case, non-public facts that only the perpetrator would know. If so, then there's a good fit, and therefore, hence, it's a reliable confession. If all the facts the defendant offered during the confession after he said, I did it, were all wrong, led to no new evidence that was corroborated, then the judge can decide it's an unreliable confession. So we're going to ask the courts to consider holding reliability hearings in addition to the voluntariness hearings. Another doctrine, we're talking about Strickland versus Washington. And Earl Washington utilized that to try and get a new trial in his case. Well, you know what? We looked at these 175 DNA exonerations, and about a third of them, we were able to determine, there's no question, the defendant had ineffective assistance of counsel. And in almost every one of those cases where a Strickland motion was filed in post-conviction setting, the court said, you know what? You're right. He did have ineffective assistance of counsel, but, getting to prong 2, no harm, no error, because there was compelling, overwhelming evidence of guilt. So all these appellate courts are finding overwhelming evidence of guilt in cases where ultimately it turns out the guy was actually innocent. So again, there's something wrong with the test if it's getting an erroneous outcome so frequently in these kinds of cases. You know, one of the doctrines, I don't know if you've studied a case called Arizona versus Youngblood. It's a particularly thorny case for those of us who practice criminal law, because in that case, a young kid was kidnapped from a church fair in, not Phoenix, the other place, Tucson. In Tucson, Arizona, and he was sexually molested for 3 hours in broad daylight by the railroad tracks. And he's eventually released, and he identifies this guy named Youngblood, Larry Youngblood, as the perpetrator. Now, there was semen stains on his pants, and they swabbed a teeny bit of semen off him, off his skin, at the time he was brought back. And the semen on his pants was not properly stored by the laboratory, and it all completely degraded because of heat and humidity. And so when the defense wanted to do testing on it to try and argue that it wasn't Larry's semen, he was precluded from doing that testing. It went all the way to the U.S. Supreme Court, and the U.S. Supreme Court said, wait a second, you know what? Unless you can show that there was bad faith on the part of the police when the evidence got destroyed, you're out of luck. You're completely out of luck. And what's interesting, Justice Stevens writes in that, he said, you know, Youngblood's lucky they couldn't do genetic testing, because had they done genetic testing, given the fact that this kid spent 3 hours with his tormentor in broad daylight, it would have just been the last nail in the coffin. Well, fast forward 20 years. The new lawyers in Tucson get hold of that tiny swab okay, that had on it both DNA from this little kid and also the semen from the assailant. And it finally gets tested, long after the Supreme Court says nothing going for Larry Youngblood. And Larry Youngblood gets cleared. The semen doesn't match him at all. And it's then thrown into the National Convicted Offender Database, and they get a hit on a guy who's a serial pedophile sitting in prison in Texas. So that's the potential here, both in terms of academic scholarship, in terms of exonerating innocent people, in terms of catching the real bad guy, reforming criminal justice. It's not a bad, day's work, but we should talk about it a little bit and see what you folks think if you have any questions.